To the people of Kpandai, your Member of Parliament, Honorable Matthew Nyindam, remains the sitting Member of Parliament for the Kpandai constituency. He remains a full Member of Parliament. He remains a proud and active member of the Minority Caucus and the New Patriotic Party. No person, no institution, and certainly no flawed judicial order can suspend the mandate you freely and lawfully conferred upon him, unless and until the appellate process, properly invoked and fully exhausted, runs its lawful course. He will continue to serve you with dedication and dignity. Let me state this emphatically and without equivocation. The minority will lawfully resist any attempt, whether subtle or brazen, to bar him from representing his people. We will not permit democratic legitimacy to be overturned by judicial improvisation. The factual background. In December 2024, Honorable Matthew Nyindam was duly declared Member of Parliament for the Kpandai constituency following a peaceful and orderly election. His opponent subsequently filed a petition challenging alleged irregularities in 41 polling stations and aspects of the collation process. The relief sought by the petitioner himself was clear and specific. He requested rerun in those 41 polling stations. And by the way, he had, prior to the gazetting of the results, filed a petition. And when counsel for Mr. Nyindam, Honorable Nyindam raised a preliminary objection, and same had been argued, and the very day the judge was to determine the matter, they quickly filed a notice of withdrawal, which was quite strange. This judge, who knows that when matters close and he's fixed a date for judgment, no matter what, he's supposed to deliver a judgment, decided to stay away from determining the matter because a party has decided belatedly to file a notice of withdrawal of the case. Yet, in a development that defies ordinary legal reasoning, the High Court issued an order directing a full rerun of the entire Kpandai parliamentary election, covering all 152 polling stations, to be completed within 30 days. As if this judge is not aware of the Supreme Court decision in the Akufo-Addo and others versus John Dramani Mahama and others in the 2012 presidential petition. The sad part of it is that the NDC candidate and his supporters were aware of the judgment before the day, to the extent that on the day of the said judgment, the regional minister led a team of NDC party faithfuls into the courtroom, anticipating the expected result. The result that they were going to have judgment in their favor. The judge, who spent minutes, walked out of the courtroom claiming that his judgment will be ready on Friday. Meanwhile, in less than 24 hours, a court order was being served on Parliament and Honorable Nyindam. What kind of kangaroo judicial system we having now in Ghana? The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of courts. We are criticizing their shameful conduct. We are not afraid. We are ready to be in Nsawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal, and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that courts occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never an acceptable approach when the stakes are this high, when a parliamentary seat hangs in the balance, when constitutional rights are imperiled, and when the vote of thousands of citizens face annulment. For a judge to casually void an entire constituency elections without first ensuring that a complete reasoned judgment was prepared and published is not merely irregular, it is judicial irresponsibility of the highest order. We have carefully reviewed the relevant authorities, including the Supreme Court's decision in Kojoba and Ghana Water Company Limited and another. In that landmark case, the court affirmed a long-standing principle, quote, "In the interest of substantial justice, a court may, in limited and carefully circumscribed circumstances, grant relief not specifically sought by a party, but only where such a relief is unmistakably supported by the pleadings and evidence, causes no unfairness or surprise, and brings true finality to the issues properly before the court." Let me emphasize,